ladies who will testify about their own experience, and so it is. And he will present now the book and his viewpoint about this very tough question. He is also the managing director of Perseus Strategies. So first I will give the floor to Bota Jademali. Welcome to you, and so you will have the opportunity to present the author. And yourself are a lawyer, and you worked with Jared. Thank you very much. I give you the floor, Bota.
Thank you very much. Okay. Bonsoir, everyone. And I'm very privileged today to introduce international human rights defender, very well recognized lawyer from the United States, Jared Genser. And you know, I'm a lawyer myself. I'm originally from Kazakhstan, and just as Jared, I work on cases about violation of international human rights law. And very often in criminal cases, when I recommend a lawyer, recommend a special lawyer to a client, I would say this phrase that if I get arrested, I would hire this guy. And today I would say that Jared is definitely that type of guy. I first encountered Jared back in 2016 when we worked together on a very, very complex case of a leader of Kazakh opposition that was prosecuted by the regime in Kazakhstan. And Jared was instrumental in releasing that person from the extradition arrest in France. And later on, because that person that Kazakhstan very much wanted extradited to Kazakhstan was released, I encountered retaliation from the Kazakh government, and my own brother was arrested in Kazakhstan, was taken hostage. And he was arrested and he was told straight away, force your sister to come back to Kazakhstan and we will release you. My brother refused to do so. So after that, he was tortured for over 2 months, and he was held in solitary confinement for over a year. And at that moment, the first person, when my brother got arrested, the first person that I kind of thought about was actually Jared. Because when you have this type of situation, when a person is arrested in a politically motivated case on trumped-up charges, in a country without rule of law, without independent judiciary, you don't have many options. And you think about what kind of, you don't have any options to fight that within the country. So you think about very few international instruments that are available for us. And actually, opinions of working group on arbitrary detention is one of those few instruments, international instruments. And of course, I called Jared, and Jared started working on my brother's case. Year later, the working group on arbitrary detention unanimously adopted the decision that my brother is held arbitrarily in a violation of international law and must be released immediately. And circumstances of his arrest should be investigated. Unfortunately, Kazakhstan has been ignoring this decision. It's been almost a year that we've been trying to enforce it. And this is one of the major problems that international human rights law encounter right now, that this type of important decisions very hard to enforce in countries that are not democratic, with authoritarian regimes without rule of law. But nevertheless, it takes time to enforce it, but because of the international pressure, because in the case you have a validation that UN recognizes that this particular case is political or in violation of international law, that helps tremendously. And in the end of the day, a lot of people that have this type of opinion, they get eventually released. And in my case, in the case of my brother, I cannot separate him from me, obviously. We have a big hope that eventually he will be released. And I think that when that happens, that will be the basis of his release will be actually the opinion that Jared delivered for us. So I'm extremely grateful to that person, and I have to say I'm very happy to people who organized this event, because actually today is the first time I meet Jared in person. This is kind of an effect of globalization. We worked together for several years, but we never met because Jared is in Washington, D.C., I am in Brussels, Belgium, and today I had this happy occasion to meet Jared. And I think this handbook is a very, very important work, because this is important for us professionals. This is important for human rights defenders, for politicians, for people that work with various international institutions. And hopefully it will be translated to other languages and will have wider circulation. So congratulations, Jared, and I'm giving floor to you.
Well, thank you so much, Bota, and it's truly an honor and a privilege to be here at the Geneva Press Club. Bota has been a friend and collaborator for many years now, and also great, of course, to finally meet you in person. You know, people like Bota, as an international human rights lawyer, are people who are heroes to me because they fight the good fight on the ground in countries around the world, and often at great personal risk to themselves. And even though she's not in Kazakhstan, she's been persecuted by the government of Kazakhstan, which has followed her around the world, trying to get her to offer false testimony against Mukhtar Ablyazov. I'm also privileged to be here today with Narman Ibadova, who is the niece of another client of mine, Hussein Abdullayev, who is a political prisoner in Azerbaijan. We have his case pending now before the UN Working Group on Arbitrary Detention. And I'm confident that an opinion that we hope and expect will go the right way before the working group will be a critical aspect of our advocacy to secure his early release from prison in Azerbaijan, and hopefully we'll have her say a few words at least about her uncle at the end. So I have before me today, which you'll see, I'm a bit of an ambitious American with many slides in PowerPoint. I'm going to go through them relatively quickly. I'm delighted that this is being webcast live online, and for anyone who would like to receive a copy of the slides, I'm more than happy to share them. Just email me at jgenser@Perseus, PERSEUS-strategies.com, and I'll be happy to share it with you. In the presentation today, I'm going to talk about what is arbitrary detention, talk about the 5 categories of arbitrary detention the working group has identified, talk about the working group, what it is and how it operates and functions. I'll describe some of the key data about the working group's jurisprudence since it was created in 1991 and has adopted more than 1,200 case opinions against more than 130 countries in the world. And then I'll talk about a case study example of a very high-profile case I worked on, that of the former president of the Maldives, Mohamed Nasheed, and our case against the Maldives. So what is arbitrary detention? Detention, it's first worth noting, is a situation where a person has been deprived of their liberty. That can happen before, during, or after a trial if there's no trial at all. And there are lots of different forms of detention. It isn't just detention in a prison, but can also include house arrest, rehabilitation through labor, or even involuntary psychiatric hospitalization. And then, of course, the question after that is what makes a decision arbitrary? And the International Court of Justice has provided a detailed explanation of what the term arbitrary means. And in short, it's a decision made on the grounds of simple preference or prejudice, without any foreseeability, by the free will of the authority concerned, without any sense of the rule of law or criterion for reasonableness or the imperatives of justice. And so that is what makes detention potentially arbitrary if it takes place in that manner. Now, the working group has identified 5 categories of detention that it has classified that it looks at cases through. Category 1 is when there's no legal basis for the detention at all, a person held beyond the sentence, for example. Category 2, violation of fundamental rights and freedoms. This is what you would ordinarily call a political prisoner, someone who's detained for using their legitimate rights to freedom of opinion and expression, or freedom of religion, or peaceful assembly. Category 3 cases relate to the violations of rights of due process, fair trial rights. Category 4 relates to the rights of asylum seekers, immigrants, or refugees, and those who are subjected to prolonged detention because of those having one of those statuses. And Category 5 implicates the right of non-discrimination when a person is being held arbitrarily because of some status that they have, as you see listed there. Now, the working group, when it issues its opinions, will say a person is arbitrarily detained under one or more of these categories. They're not mutually exclusive. You could be found to be detained because you're a human rights defender under Category 2, and there were fair trial rights violations, and so it would be a Category 3 case as well. So what is the working group and how does it operate and function? It was created in 1991 by the then UN Commission on Human Rights through a resolution of the Commission. Today, that Commission has now become the UN Human Rights Council, which has 44 thematic and 12 country mandates in the form of rapporteurs, independent experts, or working groups. The working group's mandate is renewed every 3 years and was just renewed this past September. The working group is comprised of 5 independent volunteer experts from the 5 regions of the world, currently from Australia, Benin, Latvia, Mexico, and South Korea. And they serve up to 2 3-year terms. They meet 3 to 4 times a year, and they have a small professional staff here. Over the last dozen years, the working group has sent out 1,567 urgent appeals, which are letters saying a person's life or health may be in danger, and they've adopted more than 1,200 legal opinions through its regular procedure. And I'll describe how that works in a moment. They've also conducted more than 50 country missions as well to different countries around the world, where they spend a week to 10 days meeting with anybody that connects to the issue of arbitrary detention in the country, including prison authorities, prosecutors, civil society groups, etc. So this is the regular procedure for taking the case to the working group that I describe in much more detail in my book, but all in one chart. You make a submission to the working group. The government is given 60 days to respond. If they make a request for an extension, they can have up to 1 month to further to submit their response. And from there, if they make a response, as the petitioner, you're given the opportunity to rebut or to reply to that response. But either way, even if they don't respond, the working group will then consider the case at one of its sessions. It meets 3 times a year, and it will then determine how it will act, if finding the detention arbitrary or not arbitrary, or if they don't have enough information, they'll of course ask for more information. If a person's been released, they have the discretion to issue an opinion, but sometimes they don't feel the need to do so. So why is the working group an effective body to take a case to? If you're an advocate, a human rights defender, or someone who is trying to help a person who's arbitrarily detained, there are really 6 key reasons which make this a very effective body as a general proposition. The first is its composition, independent and impartial experts from the different regions of the world. The second is, as a quasi-judicial body, it has working methods, which gives it more flexibility in how it conducts its activities. It's also effective because of the adversarial process that it undertakes, where a submission is made, the government is given the chance to respond, and then you're able to reply to that response. And so that gives the working group better information on which to make an informed judgment. Its analysis is grounded in treaties that the country has signed on to. So this is really a definitive interpretation of a country's international legal obligations. Their legal opinions serve in that function, and they have discretion and past jurisprudence to look to evolve and accumulate expertise over time. So it would be helpful at this point to just quickly look at some of the interesting data around the working group's jurisprudence over the last dozen years. You can see here that there were more than 5,000 individuals whose cases were brought to the working group across the about 1,200 cases. So there was, so you can, for example, when you make a submission, if 3 people were arrested at the same protest arbitrarily, you can make a submission on behalf of 3 people. You don't just have to make it on behalf of one. 65% of the time, it's made on behalf of one person. You can see it's made for different numbers. A smaller number of countries represent the majority of cases brought to the working group. So this is the data from 92 to 2017. China has had the most cases issued against it, about 85 case opinions. And the top 25 countries that are listed here represent 63% of the 1,200 cases brought to the working group. In its history, as I said, it has issued opinions against 130 countries in the world. It's important to note that this isn't necessarily indicative of arbitrary detention in the world today. While the working group has the discretion to take up a case itself without a submission being made, it has not done so. And so this is really reflective of who has brought cases to the working group, and on that basis, then what opinions have been issued. In the last decade, you can see this is the breakdown of the opinions themselves, the top 5 being Saudi Arabia, Egypt, China, Iran, and Venezuela. If you look at different regions of the world in which opinions have been adopted, again, this is based on who submits the cases, but about 50% from Asia, 20% from Africa, 10% from Western Europe and others, 20% Latin America, and a very small percentage Eastern Europe. These are the UN 5 regions of the world as determined by the UN. Governments in the first half of the working group's existence responded about 65% of the time. Now it's a little less than half. But either way, the working group will render an opinion even if a case was not responded to, which continues to make it an effective mechanism to engage with. You can see here that if a government responds to a communication, it can have an influence on the outcome. If a government doesn't respond, 93% of the time you'll prevail in the case. 7% a case was found to be not arbitrary or no opinion was issued. If a government responds, then it's more likely that they'll either prevail or that there'll be more questions asked that will require deferring the case to a later session. I mentioned the different categories of cases from 1 to 5, and you can see here about half the cases engaged one category, 48%, a little less than half multiple categories. You can see in more recent history over the last decade that the percentage of cases that had multiple categories implicated is up to 71%. This is in large part because in 2011, categories 4 and 5 were added, and they're broad categories that can apply in multiple cases on refugees, immigrants, and asylees, or on non-discrimination. And so there are now many more cases that have multiple opinions. You can see here the basis on which cases were decided over the course of recent years. And 70% of the time you'll see Category 3 violations, which is the violations of the right to a fair trial. As I mentioned, 4 and 5 are a low percentage of overall cases, but will be increasing over time. The working group has gotten more efficient in processing individual cases, at least as you measure it from when a communication was sent to a government and when the working group adopts an opinion. That time frame is now down to about 125 days. And this makes it a very relatively speaking, effective mechanism. If you were to take a case to the European Court of Human Rights or the Inter-American Commission and then court or the African Commission, those cases can typically take 3 to 5 years from when they're submitted till when you get an opinion. And so the working group is a much more fast-moving operation, again, relatively speaking. This relates to the working group's tracking of the release of detainees. To me, the most important metric for assessing the effectiveness of the working group is, of course, how many people get out as a result of its opinions. And of course, it's hard to prove correlation because most of the time you don't have immediate releases, the day the working group opinion is made public. But the working group has done a better job in recent years tracking releases. And so, for example, in 2018, there were 31 detainees across 31 opinions, but over its entire history, it's tracked 1,636 releases across 379 opinions. It's really only been in the last decade they've done this much more systematically, so I'm sure the numbers are much, much higher, probably close to 3,000 or 4,000 at least of the 5,000 detainees represented. But the working group is now also every 6 months will reach out to a source for a submission and ask, has the person been released or not? And this is something they only started doing in recent years. So over time, we'll see, I think, better data. Now, lastly, I'm going to in my remaining time, rather quickly run through a case that I worked on, so you have a better sense of how this works in practice. How do you combine the working group opinion with political and public relations advocacy to secure someone's release from jail? As was alluded to by Bota at the beginning, the working group opinions themselves are quite substantive and detailed. They can typically run 15, 20 pages or even a little more, representing both sides put forward by a petitioner and by the government, and then walking through a detailed legal analysis. But of course, enforcing those opinions so that a person is in fact freed is, of course, the challenge from there, especially in countries where the rule of law does not prevail. And so how does one go about doing that? This is a good case study example. Mohamed Nasheed is was a dissident journalist in the Maldives who was repeatedly imprisoned by a prior dictator of the country many, many times. 3 years in jail over about a dozen years across many different convictions and sentences. He founded the Maldivian Democratic Party, and in 2008, the longtime dictator agreed to the adoption of a new constitution. He competed against Mamoun Gayoom and won. 4 years later, he was pushed down in a coup by remnants of the old regime, and Gayoom's half-brother ultimately was elected president, Abdullah Yamin. And as Nasheed rebuilt his power base in the People's Majlis, their parliament, in 2014-2015. He became a bigger threat to Yamin, and they resurrected this charge from 2012 where a judge had been detained for taking bribes. And what ended up happening was that although that case was never prosecuted against Nasheed because he wasn't actually involved in the arrest of this judge, they recast that in 2015 as a terrorist abduction that had been ordered by Nasheed. And he, within 2 or 3 weeks, was summarily tried, convicted, and sentenced to 13 years in jail, as you can see here. In April 2015, it was announced that I was hired to work with Amal Clooney and Ben Emerson to become Nasheed's international counsel. One second here. We, the same day, published an op-ed in the Guardian newspaper about announcing our involvement in the case and talking about how he was an innocent man and a great hope for the Maldives. In late April 2015, we filed our petition to the working group, which we launched in a press event at the National Press Club in Washington, which got a lot of attention. And our submission to the working group, just briefly, said that there was no legal basis for his detention. He was charged under a very overbroad national security law, and they actually presented no evidence at the trial that he ordered the arrest of this judge at all. Literally, not a single witness or single document said he had ordered the arrest of the judge. We also, of course, talked about it as a Category 2 and 5 case because he, in fact, was being arrested pretextually for exercising his right to freedom of opinion and expression, association, political participation. It was quite clear he was also being discriminated against because he was a human rights defender. And there was further evidence of that after his conviction, because literally 2 weeks after his conviction, the parliament that was controlled by the ruling party at the time adopted a new law that said anyone in prison can't be a member of a political party. And in order to be the head of a political party, you had to be a member of a political party. So this made it impossible for him to continue to lead his party, at least legally speaking, from his time in jail. And then lastly, there were a whole wide array of due process abuses that I'll talk about later, but they were really egregious and extraordinary. So we immediately started working with the U.S. Department of State. Secretary Kerry, just a few days after we made our submission to the UN, traveled to Sri Lanka. He spoke publicly in Sri Lanka about the fact that President Nasheed had been imprisoned without due process there. We also started working with members of Congress. This is a joint press statement from Senator McCain and Senator Reid, who were the chairman and ranking member of the Senate Armed Services Committee, that reached out to the U.S. Secretary of Defense and Secretary of State, asking them to engage on the situation relating to President Nasheed. It was announced in June 2015 that the Maldives had hired Cherie Blair, who, of course, is the former Prime Minister's wife and generally highly regarded lawyer in the UK. It was later reported they were paid £420,000 for their contract. It's worth noting we were working pro bono for free on the case. Throughout the case, we kept publishing op-eds in various newspapers around the world. This is an op-ed I had in The Diplomat, talking about the two Maldives. This was after the Maldives had appeared at the UN, for their Universal Periodic Review, and they presented this one image of the Maldives as this wonderful human rights respecting place, and that wasn't really the experience of most people in the country, especially my client, the former president. In early July 2015, we traveled to Brussels, Strasbourg, and Geneva with Laila Ali, President Nasheed's wife. You can see it was actually my picture. I was standing in the background with Laila when she met the former High Commissioner, and on the right you can see Laila with the former President of the European Parliament. Meanwhile, a short time later, I was deported from the Maldives, which is always a good thing when a government deports me, because it's really a dumb move to deport an international lawyer, because you're denying access to counsel, which is one of the rights under the International Covenant on Civil and Political Rights. And I was then able to do a press conference in Sri Lanka, which got a lot of attention about my having been deported. From there, in late July 2015, the government of the Maldives filed its response to the working group petition. They argued some procedural issues. They claimed that the case had to be through a final appeal in the Maldives, which wasn't accurate. They claimed a conflict of interest. On Category 1, they simply asserted that he was convicted by a Maldivian court in accordance with Maldivian law. That generally isn't good enough to win a case. You have to show that you also abided by your obligations under international law. Again, they just said that the charges weren't politically motivated, but they didn't provide any evidence to support that claim. And they made a bunch of, arguments to try to justify the due process abuses. The due process abuses, it's worth noting, were egregious. For example, Nasheed wanted to present 5 witnesses in his defense. That included his chief of staff, his minister of defense, and a number of others that would have testified, that at no time had he ever given an order to any of them, and they were the closest people to him, to arrest the judge. And the court refused to hear that evidence and claimed in its written conviction that it published that there was no need, this is almost a direct quote, but something along the lines of, there was no need to hear the defense's witnesses because they never would have been able to refute the prosecution's case. So when you say things like that as a group of 3 judges in that case, it doesn't exactly sound like you're complying with international fair trial rights. From there, the UN High Commissioner for Human Rights called for Nasheed's release. This was in August of 2015. I was able to get into the country in September 2015 with Amal Clooney, and we were able to visit Nasheed in jail. And again, to make things much easier for us, it turns out that they eavesdropped on our attorney-client privilege conversation. We knew this because one of the things we discussed with Nasheed that was later made public was when we met him for the first time, one of the things he said to us is, please tell my wife and 2 daughters, I really want them to get out of the country as quickly as possible to the UK and claim political asylum there, because the situation on the ground is becoming very dangerous. I don't want anything to happen to them. And we were literally in the launch ride from Mafushi prison back to the main island of Male when I got a phone call from Laila Ali, Nasheed's wife. Literally, we just left like 10 minutes earlier on the boat, and we're still on the boat. And she said, what's this about me going to the UK? And I said, wow, word travels fast. And she said, that it turned out she had, there was a senior person at the prison whose wife was a good friend of hers, and that senior person had told his wife that this is what had been said in the conversation, and she immediately called her good friend, Laila, and said, your husband wants you to go to the UK. So we then had a press conference blasting them from eavesdropping on our conversations. The very next day, we've been working with the New York Times for a while on this. They published an editorial urging his release, a Maldives leader unjustly jailed. It doesn't get any better than that, given the global reach of now the International New York Times. 3 days after that, the UN High Commissioner for Human Rights presented his annual address, his annual report to the Human Rights Council. He mentioned very few cases by name, but the government of the Maldives at the time had moved him to house arrest, they said on a permanent basis, although then they had returned him back to jail. And so the High Commissioner spoke out publicly saying that what was happening in the Maldives was very disturbing. By the end of September 2015, we had received and made public the Working Group Opinion, number 33, 2015, which found he was held illegally and urged his immediate release. The Working Group concluded he was being held under every category we had alleged, that he must be released immediately and given an enforceable right to compensation. They rejected the government's arguments on procedure. They said it was clearly impossible under Category 1, which is no justification for the imprisonment, to invoke. It's impossible for the government to invoke any legal basis. In simply producing a list of witnesses and evidence in its response, the government had failed to rebut the assertion that there was no evidence produced at the trial. They concluded his detention, of course, resulted from the exercise of his right as an opposition leader, and they explained that in much more detail. And then they found a lot of violations of his rights of due process. The government at this point was floundering all over the place, which is when it really gets fun as an international human rights lawyer. I found online that they had just hired, because you have to file with the U.S. Department of Justice, a lobbying group called the Podesta Group, which is now out of business because of some of its work on Ukraine and other high-profile issues now in Washington. I found online that a filing that they had just hired, Maldives hired the Podesta Group on a $300,000 contract to lobby in Washington, literally within a few days of the working group opinion coming out. And then the same day that I made that public in a tweet with a copy to the contract, which was made available by the Justice Department online, the government then denied hiring them as a lobbying group. The pressure mounted, and Amal Clooney and I were then labeled enemies of the state because we had spoken about targeted sanctions against individuals in the Maldives, against those responsible for his imprisonment, and how that should happen. And what happened is that a member of the ruling party then proposed a piece of legislation that actually barred extraterritorially, any person anywhere in the world from calling publicly for the sanctions of anybody in the Maldives. So in other words, if I spoke in the United States urging that the Maldives be sanctioned and people be sanctioned, I could actually be charged with a crime on that basis in the Maldives, which could then try to request my extradition on the basis of that criminal charge. And of course, I thought this was all very amusing because I knew the United States was never going to extradite me on such a claim. But the head of the ruling party's parliamentary delegation didn't quite understand that I described being proud that I was called an enemy of the state and how ridiculous what it was that they were doing. And his response was to say, no, you may be misunderstood. Indeed, you two really are the enemies of the Maldives. And again, when governments are doing things like this and they're responding to me in this way, it's clear that they're flailing all about. Meanwhile, we kept up pressure on the government in the media. Another op-ed you can see here in Foreign Policy magazine. The European Parliament adopted a resolution urging Nasheed's immediate release, importantly citing to the working group opinion. This is how you instrumentalize the working group opinion in order to get maximum pressure on a government. The Wall Street Journal had an op-ed there in December of 2015, a human rights crisis racks paradise, again drawing attention to what was going on. It wasn't helping matters that Cherie Blair's right hand, we learned 6 months after we got involved, that in fact he had tried to pitch to represent President Nasheed himself as a client prior to when he and Cherie Blair started representing the government. At the time that we were hired in April of 2015, Nasheed's team was getting offers of help from many people around the world. Like they were inundated with offers. Most of them were people requesting to be paid. It turns out that one of those people was Toby Cadman, who was the right hand of Cherie Blair. And in fact, in his proposal, he had submitted in writing to Nasheed, he talked about, how Mr. Nasheed took the Maldives on the first step towards true democracy. His arrest and trial is a politically motivated show trial aimed at cementing further an already authoritarian regime. And the staff to Nasheed only remembered this about 6 months later after Cadman took a higher profile in the case and found this and gave it to me, and we went public with that. And it turns out that, before we decided to represent the government of the Maldives, we said Nasheed was a hero. So again, probably not making for a good follow-up conversation between Cherie Blair and Toby Cadman and their client, the government of the Maldives. In early 2016, we launched a major report calling for the sanctioning of key perpetrators. We met Secretary Kerry, we met Nancy Pelosi, the Speaker, now the Speaker of the House, Senator McCain, again, high-profile Republican. The pressure was mounting on the government of the Maldives. I had an op-ed in the Washington Post. We, at that point, over that weekend, had just gotten word that the government of the Maldives was going to release Nasheed. This is what Yemen had said privately to the U.S. and to the U.K. But then they changed their mind. And then I was able to prompt, working with U.S. diplomats, Secretary Kerry to reach Yemen to say, you better not change your mind. And we were able to then, again, this was my idea, I thought it would be very helpful if Secretary Kerry, as he's at the airport, were to call President Nasheed before the plane left, in case Yaman might change his mind about letting him go. And I told the staff, his staff on the ground, make sure to get a picture of it, send it to me, I'll tweet it out. You can see here I had a large number of retweets and likes of this, but this was, you know, as you can see, Mohamed Nasheed on a call with U.S. Secretary of State John Kerry to show that we've got, you know, the full weight of the U.S. government behind us. And then Nasheed flew to Colombia, Sri Lanka, and then on to London, where he arrived on January 19, 2016. Let's see if this works here. Let's see. And this is me recording the image of him getting off the plane. And it's moving slower. I guess there's a bit of a drag here. So, but this is he being reunited with his wife after all this time. Oh, maybe. If not, we'll move on. Whoops. All right, well, we'll move on. I have more pictures in a second. This was a short time later. Nasheed was laughing so much because he had just been asked a question of, why do you think they let you go? And he had just said, because of my great lawyers. We were all standing next to him. So it was a joyous day, as you can imagine. This was actually the beginning of a new chapter, though, for President Nasheed in his struggle to restore democracy to the Maldives. A few days later, we met with Prime Minister Cameron in number 10 Downing Street, who had been friends with Nasheed for many, many years. It wasn't over for Cherie Blair. We don't know really what has happened with this, but she ended up facing a corruption probe, or at least the threat of a corruption probe based on her deal. It turns out she wasn't actually paid by the government of the Maldives. She was paid by some random businessman who she hadn't heard of, and rather than, you know, when I've worked for governments, I insist I would only be paid from a government account. She was paid by some random guy. Turns out the random guy had been given $5 million of stolen funds from the government of the Maldives, and then had been asked by the vice president of the Maldives at the time to just pay that bill that Cherie Blair is owed, please. And she was paid with stolen funds from the government of the Maldives. Whoops. And then there were protests in the streets against her, asking that the money be given back. It's not clear what happened from there. I guess we'll see if anything happens. It was a few years ago, but not probably her finest hour. Later, what was obvious was confirmed, that the judges in his case had been paid off in order to rule against him. The former vice president, who then got displaced by Yaman and sent to jail, was more than happy at that point, once he was sitting in jail, to tell the real story of what happened in Nasheed's case and how he had paid the judges in order to rule against Nasheed. Later, the UN Human Rights Committee ordered the Maldives to requalify Nasheed to run for president, but President Yaman ignored that order. Last year, September 2018, his close friend and ally, Ibrahim Soli, was elected president of the country. On November 1st, 2018, after the election, Nasheed returned home to an extraordinary welcome. That gives you a sense of it. The Maldives is a country of only about 400,000 people, and you get a sense that the crowds were quite large. In late November, I was in the Maldives when the Supreme Court reversed his conviction after previously, 6 months earlier, affirming his conviction on the final appeal. It sort of goes to show you, as you can see on the left, he gets cleared. On the right, his sentence was upheld 6 months earlier. I met President Soli for the first time and had a fun time tweeting out that I went from being an enemy of the state to now meeting the new president. In April last year, early this year, Nasheed was elected to the People's Majlis, and on May 28, 2019, he was elected Speaker of their Parliament. And literally just a few weeks ago, to bring it all back to the book, I was back in the Maldives again and gave him a copy of my book in the Speaker's office. You can see here he sent out a kind tweet about the importance of the working group opinion. So that's sort of the story from beginning, middle to end on Nasheed's case. These often truth is stranger than fiction, and how these play out, is always an interesting journey, to say the least. And so, I would just conclude with one of my favorite quotes from Mahatma Gandhi, which I think is very applicable to this kind of work. First they ignore you, then they laugh at you, then they fight you, and then you win. Before being totally concluded here, I want to give Narman Ibadova an opportunity to come up and speak briefly about her uncle. Because the reality is, in talking about Nasheed's case, of course, that's in the past. The work continues. I myself have taken more than 45 cases to the Working Group on Arbitrary Detention over my career. Of course, one can't rest on one's laurels. There's always more cases to work on. Iskandar Yurimbetov in Kazakhstan, Hussein Abdullayev in Azerbaijan, and of course, many others. So let me leave it at that and let Norman just say a few words, and then I'm happy to answer any questions.
Thank you very much, Jared, for your presentation, and congratulations on your work. And I hope one day you will be able to present my uncle as you did for Mohamed Nasheed.
Absolutely.
And I hope that the justice will be on our side, and my uncle will be released soon.
Well, let me just mention briefly about her uncle. Her uncle is Hussein Abdullayev, who's a businessman in Azerbaijan. He was an elected MP, in fact, after a long time being aligned with the government, became an elected MP, and then stood up and spoke out against the government in the parliament itself. He was then physically assaulted, actually, by a ruling party MP, and then charged with hooliganism and sent to jail. Many years later, literally like 4 years later, the European Court of Human Rights found that he, in fact, was arbitrarily detained because the court in Azerbaijan refused to allow him to submit the video from the parliament floor, which showed he was physically attacked himself directly and that he responded in self-defense rather than actually having initiated the assault. By 2013, it was clear the government was going after him in a lot of different ways, and he is a composer, a musical composer among many talents, and he published a song that was entitled, "Don't Be Silent," and at the same time published a video online that has had now tens of thousands of views that put that musical score and the song to video images of Azerbaijani police and security forces beating up unarmed protesters. And literally the next day, they then began an investigation into him on alleged economic crimes. Initially, a red notice was issued against him by Interpol. It was later dismissed because it was an abusive red notice. He was able to get political asylum in Germany, and just in April of 2018, he was traveling to Turkey, got grabbed over a weekend by Turkish authorities who, in an extraordinary rendition, sent him back to Baku, and he's now been convicted and sentenced to 6 years in jail for these manufactured crimes in a show trial that I witnessed myself firsthand. I was denied access to him in Azerbaijan, which is a clear violation of his rights under international law. We asked 4 different government authorities for me to be able to see him, from the Attorney General's office, the Minister of Justice, the court itself, the President's office, their ambassador to Washington, all pointed to other people saying, they weren't the ones responsible, and of course I never got access to him. And when I was in the court and saw the case firsthand, the trial, he was held in a glass cage, which is a violation of his right to the presumption of innocence. Most of his lawyer's attempts to present information and evidence were declined. And at a certain point, he was protesting the proceedings and was physically manhandled and dragged out of the courtroom. The proceedings continued. And of course, a person has a right to be present in proceedings against them. They should have suspended the trial. They didn't do that. So we've obviously just gotten started on Hussein Abdullayev's case this past summer. And we've just taken the case to the working group, which has engaged the government of Azerbaijan. And obviously, there'll be still a road ahead. But, his case is very, very clear. I'm confident we'll prevail at the working group. We'll leave them to undertake their own process, and we'll put enormous pressure on the government of Azerbaijan until your uncle is freed.
Thank you.
So happy to answer any questions that anyone might have.
It's very important that this book now exists in English. The region of the world where it must be understood and read are numerous, and I think China, it was on the top of the list, but other countries. When are you planning a Chinese and Russian translation?
Well, thank you for the question. Challenging one to answer because everything costs resources. Right now I'm trying to raise the money to make the book publicly available for free online. Cambridge University Press published the book. Even with the discount, it's quite expensive. And so I've raised 10,000 of 30,000 I need to raise in order to make it free and available online. That would at least help NGOs, human rights defenders, and lawyers. Each of these translations, because the book itself is about 650 pages with 6,000 footnotes, is a big job. And to get legal translators to translate it probably is going to cost $50,000 to $60,000 per language. And so I'm in the process of talking to a lot of people about how to raise the resources necessary to to be able to have this translated. I don't want it to be a book sitting on a shelf that that nobody has a chance to actually see. Although the book itself is a treatise about arbitrary detention under international law, grounded in international law as it relates to arbitrary detention and the working group's cases. There's almost a 100-page section in here on the process by which you can most effectively take a case to the working group. And there are 5 case study examples in the book, Nasheed's case being one of them, Mukhtar Ablyazov's being another one, of 5 of my individual cases from different parts of the world, and how I combine the legal advocacy at the working group with the political and public relations advocacy to secure the release of my clients. So it's intended to be really a how-to guide for freeing political prisoners, and I obviously want it as widely available as possible.
Hi. Why hasn't this book been written earlier? Why is it so groundbreaking today?
Thanks for the question. Well, it is a good question. I mean, I have been working with the Working Group on Arbitrary Detention since really I was a law student when I took my first case to the working group back in the year 2000, 1999-2000. The working group itself didn't even have a publicly available database of its cases until the mid-2000s. You're able to refer to past cases as precedent, like in a common law tradition. But it used to be that they were all published once a year in an annual report as an appendix, and the 50 or 100 cases would be in 300 or 400 pages, of appendices that were impossible to search. And I worked with the NGO that I'd founded, Freedom Now, and with the Thomson Reuters Foundation to make a publicly available database pro bono for the working group. I think the reality is the working group is only coming to the fore and becoming much better known, probably in the last 5 or 10 years. And there are, I think, a lot of different reasons for it. I think, unfortunately, one of the reasons is the number of arbitrary detention cases that we've seen proliferate in different parts of the world. They've also taken on a number of high-profile cases, most of which I would say they have gotten right. They have also gotten at least one case, in my view, quite wrong. On the Julian Assange case, where he, of course, was in the Ecuadorian embassy, had entered there to avoid being sent to Sweden. The working group, in my view, quite wrongly found that he was arbitrarily detained, even though their own definition of house arrest that they published 25 years earlier said that house arrest is is a situation where a person is on closed premises where they are unable to leave. And obviously at any time Assange would be able to leave. But there have been a lot of high-profile cases that I've worked on and other people who have worked on that have gotten a lot of attention. One of my other clients, Anwar Ibrahim, the former Malaysian Deputy Prime Minister, was released in part on the basis of the working group opinion. He will likely become, we hope and expect, he'll become the next Prime Minister of Malaysia by next May. And I also had worked on Aung San Suu Kyi's case. For the latter 5 years, she was under house arrest, and they issued written opinions in her case. So I think some of these, and for example, on her case, when I was working on her behalf, I was able to get President Obama to publicly talk about the Working Group on Arbitrary Detention opinion, right? So he put out a statement in his own name where he called for her release back then on the basis of a Working Group opinion. So I think we've seen greater attention to what the Working Group has done. More attention is needed, but the other thing I would say is equally important is more resources are needed for the Working Group itself. The Working Group has 5 volunteer experts that themselves are writing these written legal opinions. They're really at maximum capacity, doing about 100 opinions a year. Each of them are writing about 20 to 25, 20 to 30 page opinions, right, as volunteers. But there is a backlog of cases at the Working Group that have been received, and obviously it's terrible, but the Working Group only has, 2.5, 3 staff, that there would be delays in even sending a communication to a government because the Working Group doesn't have sufficient staff to be able to handle it. So one of the things I would also urge for any governments that might ultimately see this or foundations, one can make voluntary contributions to the Office of the High Commissioner, and they can be earmarked for specific mandates. And so strongly encourage anyone with the resources to make voluntary contributions to the Office of the High Commissioner and have them designated for support for the Working Group on Arbitrary Detention. The primary donor currently for the Working Group, going back to its founding, is the government of France, which has been incredibly generous over many, many years. It was the French jurist and human rights lawyer Louis Joinet, who had been initially asked by the former Commission on Human Rights to do a report on arbitrary detention in the world, and from that he recommended the creation of the working group, and he became actually its first chair. And so France has been very supportive, but clearly at this stage, and my book is not going to help in this regard, with the larger numbers of people looking to access the working group, we need to keep it a nimble and fast-moving institution that can much more rapidly assess these kinds of cases. Any other questions? One last one.
Well, thank you very much for the presentation and congratulations for the publication of the book. I have a question regarding the enforcement of the decisions of the working group. It was mentioned that they're not enforced in places where the rule of law is not respected and where authoritarian regimes, but also in other places where the rule of law is there and it's democratic states, they're not implemented. So I'd like to ask you whether those are the reasons that perhaps prevent the implementation of the decisions of the working group. And also a related question, if I may, you mentioned that the working group has a quasi-judicial nature. I would like to ask you, where is this quasi-judicial nature coming from? I suppose from the mandate that was given by the Commission. If that is the case, is this the only special procedure that has this nature? And how is it different from, for example, other human rights mechanisms such as the treaty bodies and the decisions of the Human Rights Committee, for example? And given the nature of the working group, how they should be approach by judges at the national level and how they should be interpreted, taking into consideration that the decisions of the Human Rights Committee are coming from a treaty obligation and the decision of the working group are not coming from a conventional obligation. Thank you.
Well, thank you for the highly detailed question, which obviously comes from a point of a lot of knowledge on your part. I could write a second book, perhaps answering those questions, but let me try to give you my best quick answer to the different questions you asked. So when it comes to enforcement, there are enforcement challenges in authoritarian states as well as democracies. Ultimately, I think a lot of governments don't know quite what to do with these opinions, because they're not used to being questioned on their domestic detention practices, and it is a challenge for democratic states as well as less democratic states in terms of implementation. In terms of how I would compare a working group opinion to let's say opinions of, the Human Rights Committee, which oversees interpretation of the International Covenant on Civil and Political Rights, which is of course a treaty. I would say the following: the views, as they're referred to, of the Human Rights Committee are also not legally binding in the same way that the working group opinions are not legally binding. But nonetheless, in both cases, they are definitive interpretations of a state's obligations under an international treaty. And as such, I believe that they have strongly persuasive authority, because this is an international body that was set up by first the Commission on Human Rights, now the Human Rights Council, that has provided a specific legal mandate to adjudicate individual cases of arbitrary detention and to publish written legal opinions. And a majority, it's actually now unanimous every time, but unanimously, the Human Rights Council, reconfirms every 3 years the legal mandate that it has. So 47 states that represent the Council, that are elected by the General Assembly, have endorsed the mandate of the working group and its authority to be able to adopt these kinds of opinions. It is true that the Human Rights Committee, the Working Group on Arbitrary Detention is the only one of the UN Special Procedures that actually publishes written legal opinions based on an adjudication process, an adversarial adjudication process. All of the other special procedures follow a similar kind of format, of having a special rapporteur or independent expert or working group send an allegation letter to a state asking for its response. But the working group is the only one that, when it receives the response, then conveys it back to the source to get further information, or either way then publishes a written legal opinion. And in the case of the other special procedures, they then will make public only simply that they made an allegation letter and here's what it said and here's what the state said in response. But they don't actually render their own written legal opinion about what they make of the communication they sent and the response of the government and whether or not there was a violation. So the Special Rapporteur on Freedom of Opinion Expression will say, for example, there's been an allegation that you restricted this person's free speech rights by, let's say, shutting down temporarily detaining people at a protest, right? And so what the Special Rapporteur would say to that state is, we've received an allegation that the state responded to this person's speech or freedom of opinion expression by doing this. What is your response? The government will present a response back, most likely saying, no, we didn't. Here's why we think it was valid, right? And then both of those get published on the Special Rapporteur's website. But there isn't a follow-up written conclusion by the Special Rapporteur that I have made this complaint, and this is the response, and it's my assessment that this person's right to freedom of opinion and expression was in fact violated. So I think in that sense, it's unique among the special procedures. It's more analogous to the optional protocols under the various treaty bodies, like the CAC Committee on Torture or the Human Rights Committee, which have more formalistic legal processes that will lead to an actual adoption of a view in accordance with the treaty body's method of work. In that regard, if you have a case before the Human Rights Committee, the Working Group on Arbitrary Detention would defer making a decision about a case until the Human Rights Committee first heard it. That's the only only independent mechanism that they would defer to. So you can get sequential opinions. Typically, I would not take a case, for example, to the Human Rights Committee on arbitrary detention because it's much longer. It's a 2 to 3 year process. And arbitrary detention is one of dozens of issues that they handle, whereas the Working Group on Arbitrary Detention decides things much quicker, and their focus and their expertise is on arbitrary detention. But in Nasheed's case, as I mentioned quite quickly, first we won his case and found he was being arbitrarily detained by the Working Group on Arbitrary Detention. After we were able to get him out, we then followed a subsequent complaint to the Human Rights Committee because the Maldives was a party to the ICCPR and to the optional protocol. And what we said in that complaint was not about arbitrary detention directly, but we said that his disqualification to run for political office that emanated from an arbitrary detention was a violation of his rights to political participation in the Maldives and his ability to run for president, because he was disqualified from running for president based on an arbitrary detention. And the Human Rights Committee considered that complaint and the response from the government and then agreed with us and found that any disqualification to run for office on the basis of an arbitrary detention is in fact also illegal and arbitrary. And therefore, the Maldives was instructed to say that he was entitled to run for president. Of course, the government also ignored that opinion as well. But I hope I've covered the range of the issues that you discussed, but they were all very good questions.
Is there any other question? If yes, one more question.
Good evening. I have a quick question about the ex-president of Peru, Mr. Toledo, who's in the United States. Are you familiar with this case, and are you working on it, perhaps?
I only kind of have superficial knowledge of it. I'm not working on his case.
Okay, then, thanks for your interesting question, and thanks especially to Jared Genser for this very interesting and vivid presentation, the author of a book just published some days, weeks ago, probably days, let's say. And I remind you, the book is called The UN Working Group on Arbitrary Detention, Commentary and Guide to Practice. Thank you, Jared, and thank you to you all.
Thank you very much.